This is the matter of Alt versus Alt, case number 25-01891DO. Present in the virtual courtroom, we have both parties, as well as attorney Christian Krupp on behalf of the plaintiff and attorney Michaela Rehnquist on behalf of the defendant, Ms. Alt. We're here on the plaintiff's motion for a temporary order. And I also would indicate, Ms. Rehnquist, I didn't see that you filed an appearance.
Yes, my law firm did. Rachel Terpstra is the main attorney on this case, but Gilo Groom Terpstra McAvoy, I believe, filed an appearance, should have filed an appearance.
Recently?
Yes. Yes, looks like on March 24th, a appearance was filed.
Okay. It probably just hasn't made it to the file yet. I also did not see a response. Did you file a response?
Yes, we did. We also filed a response on March 24th.
Okay, just for future information, it's best to email my clerk the judge's copy because I don't use the paper copies anyway, and I get it quickly that way. But obviously, I haven't read it. So, all right, Mr. Krupp.
Thank you.
I have read the motion.
Yes, the facts aren't super complicated in a sense. And I don't think there's an issue. For example, each of them are going to have their respective vehicles. My client actually does have a motorcycle, which I understand the defendant is now hid. Obviously, we're going into the spring. In the winter, it wouldn't matter, but we are going into the spring, summer, and he would like to obviously have his motorcycle and have exclusive use of his motorcycle that was owned prior to the marriage. The big issue, obviously, is the house. I quite frankly, in 35 years of doing this, I haven't seen such a massive frontal attack by a person in a divorce, in a sense of she went and got a PPO to throw him out of his house that he owned prior to the marriage. She called and canceled all of his credit cards so that he had no access to money, cleaned out the bank account, and then also got a PPO so he couldn't go back to his house. I've never seen such a frontal attack before a divorce is filed from somebody. So basically, he was homeless, living in his parents' basement with no money, no credit cards. He now has, and weirdly enough, I said, well, are the credit cards joint? He said, no, the credit cards were solely in my name, but she has my social security number. She called all the credit card companies and said that my credit cards were stolen, and then changed all the information to her email and her phone number as contact information on my credit cards. I've never seen somebody be so aggressive and vindictive and angry. So my client was basically like, he had to borrow money from his folks to even hire a lawyer because he had no credit cards, no nothing. That being said, at this point where we're at is my client purchased this home. The primary issue is exclusive use of the home. My client purchased this home in 2002. He's owned this home for 23 years. These people have been married for 2 years. She got a PPO to throw him out of his own house that he owned for over 20 years prior to the marriage. My client right now is currently getting disability. The defendant is earning over $200,000 per year as a realtor. Obviously, the equities are very clear in the sense that my client wants exclusive use of the home. He wants to go back to his house that he's owned for 20 years prior to the marriage. This person has been married to him for 24 months, managed to throw him out of his house and left him penniless. It's outrageous, quite frankly, in my opinion.
Today, we enter a courtroom full of tension.
But the gist of the matter is plain and simple. My client wants to be back in his house. We're requesting the court enter an order giving an exclusive use to his home that he owned for 20 years prior to the marriage. There are no minor children. This is second marriage for everyone. I was asking my client, he thinks that it's his wife's fourth or fifth divorce. Unsure, but I'm guessing that's how she knew how to do all this stuff. We're obviously arguing about the PPO. The PPO really doesn't matter in a sense. Once he's back in the house, he really doesn't care whether he has contact with her, doesn't need to have contact with her. That kind of ends the issue in a sense with that. It's a non-issue, but he does want to get back in his house. The thought that you could take a PPO and do the PPO ambush before the divorce is horrific. So we want exclusive use of the home. We want to get back in the house. My client needs a place to live. He's on disability.
You're repeating yourself, Mr. Krupp, and I did read the motion.
So anyway, that's where we're at, Your Honor. We want exclusive use of the home. I don't think the vehicles and the motorcycle are an issue. We are working through the credit card stuff, but obviously we also request the court enter an order that she not use his information to cancel credit cards.
All right, Ms. Rehnquist.
Thank you, Your Honor. So first, there's a lot of things that were just mentioned that were not in the motion, but I will say we reached out and we thought that we could get a proposed stip as to the majority of the motion. We agree that they have their vehicles that are in their possession, and that they pay the vehicle payments and insurance. We also agree that they will keep each other on their other insurances as well. They're both covered, and so we want to keep that for now. And we also agree to a temporary restraining order so that neither party can transfer, sell assets, anything like that, as well as not accumulate large amounts of joint debt during this pendency of this matter. So that part, I think we agree to. The only part that we don't agree to, as I think you can tell, is the exclusive use of the marital home. Frankly, the only dispute that we have is that, and it's because the plaintiff states in his motion that the parties are unable to cohabitate during this proceeding, but the reason is not elaborated on. The reason they can't cohabitate is because he came home on February 29th, stood over and was shaking my client, which necessitated and screaming. And she had to run to another room and call some mutual friends of theirs to get him to stop and to calm down and stop abusing her. And so frankly, if he never did any of that and the things that happened in the following days where he would show up screaming, pounding at the door, she had to call the police. Obviously, you know the facts of the PPO, so I won't go any further, but he's the whole reason why we have to decide who gets exclusive use of this marital home. And she's been living in it for the past month. Frankly, we believe that financially she's going to be the one that ends up with it, or they're going to have to sell it. All this financial stuff that's come up today is new to me. I don't believe that she has canceled any of his credit cards or done anything with his financial being. So that's something I think for a different day, if they can present evidence as to that. But we think that it would be wrong for the plaintiff to be rewarded for the actions that necessitated the PPO. And my client should not be forced to move out of the marital home that she very well may end up in. At the very least, we would like it for the pendency of the case, but at the very least, it seems like the plaintiff is disputing the PPO. We have a PPO hearing in April. We would at least like to get through that and have my client remain in the home at that time. So we would request that she be able to stay, because the only reason we're here arguing this motion is because of his actions.
All right, thank you. Regardless of the PPO, the court has to look at, I did not hear it disputed that this asset, this home was premarital in terms of Mr. Alt owning it for significant number of years. And that that's clearly a huge issue in this case, and this is a short-term marriage. I also take note that Ms. Alt admits that she makes significantly more money than Mr. Alt.
And she does not admit that. I apologize. I didn't want to cut you off, but she does not make a significant amount more. There was 1 year she made a little bit more, but she's been taking care of him for the past couple of years after a car accident. She does not make a significant amount more. And actually the amount of money that she put in was dumped into the house, so that we believe that this house is not going to be a premarital asset at all. We're going to be fighting that.
Okay, all right. All right.
Now, obviously, Your Honor, we would adamantly disagree.
I obviously that's what makes a divorce trial.
Exactly.
But we're here on a temporary order. What I will do is I will give Ms. Alt 60 days to vacate the marital home, and he will have exclusive use at that time, and then we will work out the rest of it.
Okay. And personal property, other than, furniture is not going anywhere, and it's 60 days from today's date, so I don't get I'm dragging out the temporary order so I can buy myself a month.
It's 60 days from today.
Okay, I'll prepare an order, Your Honor. Actually, I think I attached an order, but I'll add the 60 days in.
And then I did hear some agreements Ms. Rehnquist put on the record.
I think vehicles are agreed upon. I don't think that's a problem. I think non-disposal of assets is agreed upon.
Okay. And then the motorcycle, is that covered with the vehicles?
I didn't have it because it was cold when we did originally file the motion, but now it's starting to get warm and it's going to last a long time. So my client would like to get the motorcycle. It was his again before the marriage, so I'm not sure why that would be an issue, but.
Ms. Rehnquist?
We again are disputing that that is a marital asset, the amount of money that has gone into that motorcycle from my client, as well as we're also concerned of him just selling off assets. So we do not believe that that should be moved at this time. We think the vehicles are plenty at this point, just to separate the two vehicles.
There's a restraining order that's going to be in place against selling assets. And that's certainly, that motorcycle, whatever the value may be, can certainly be set off in the final division of property. So I'm gonna award him the motorcycle at this point.
I'll put that in the order and submit it, Your Honor. Thank you.
All right,
Have a good morning,
thank you, we're adjourned.
or a good weekend, I guess.
Thank you, Your Honor.
A shocking claim is about to turn heads fast. Every eye in the room locks on as the allegation lands hard.
We're here on the defendant Ms. Alt's motion to compel discovery, as well as a motion to compel the sale of the home. We'll take the motion to compel, or to compel the sale of the home first.
Okay, thank you. Your Honor.
And I have read the motion and the response.
Okay, thank you, Your Honor. Since you've read the motion, it's clear that both the deed and the mortgage are in both parties' names. The mortgage had been in forbearance for many months prior to the filing of the divorce. That forbearance was set to expire at the end of May. We did notify plaintiff's counsel that it needed to be addressed immediately in order to keep the home in forbearance. That was not done. We did include several, the Round Point mortgage, our correspondence with opposing counsel, bringing this issue to his attention. We also included the loan documentation from Round Point Mortgage regarding this supposed modification to the loan. I would note that on the Round Point Mortgage information, it's clear it is still in both names. It is not, as plaintiff stated, his attempt to refinance into just his name. This modification still is in both names, and the modification required that plaintiff actively accept this by 6/24. Now, my client did follow up with the mortgage company yesterday, and as of 7:30, 2 days before this hearing, the plaintiff did finally reach out, accept this modification, and make the July payment. Under the terms of this mortgage modification, again, step 2, every single month the payment must be made timely in order for this to remain in place. So plaintiff's response that, hey, no, I'm in the middle of a modification, no payment is due, is absolutely false. And obviously the plaintiff realizes this, or he wouldn't have logged on and made the July payment 2 days ago. So at this point, though, the failure to do that timely has caused a huge credit hit to my client. I can only assume to the plaintiff as well. In addition, plaintiff's income at this point appears to be only around $3,000 a month in disability and a pension. There is no way he's going to be able to refinance $329,000 on his own. So there's no way he's going to be successful at applying and getting this mortgage in just his name. As of December, my client would have to sign off on resuming this mortgage, and she is unwilling to do that on a home that she's not going to live in and certainly does not want to be responsible for anymore. At this point, based on the plaintiff's failure to abide by this court's order and maintain the mortgage until 2 days prior to this hearing, this house should be sold and the proceeds should be escrowed until we know how this house is going to be resolved. In addition, I do want to respond to the plaintiff's continued claims that this was his house for 20 years. She just came in. She basically is spending all this money. That's absolutely false. I do want to note that the Exhibit A that's attached based on some accountant's review, I don't know where the information came from, but garbage in, garbage out. For example, on one line item to the IRS, it shows that there's not been any payments to the IRS in the last 4 years, and that's absolutely untrue. There was a $5,000 payment as recent as early this year in 2025. That is not on this statement. It also doesn't show all of the payments that my client's been making out of her business account for all of their personal expenses. None of that shows up on here. What does show is that Mr. Alt has contributed approximately $185,000 to the marriage over the last 5 years, and my client has contributed $362,000, and that's without all the expenditures that are coming out of her business account. And again, they claim that she
Get ready. This twist in testimony changes everything now. What seemed clear moments ago is suddenly clouded in doubt.
she's absconded with all of this money, and that's why the house is in the problem that it's in. That's absolutely false. By their own chart, which is incomplete and incorrect, in the years 24, 25, there's been no transfers to herself or taking monies out of these accounts. So how is that put this house in foreclosure? It makes no sense. The fact is that Mr. Alt failed to follow through with the mortgage company, and that has been the problem, as he was court ordered to do. And again, this chart shows none of the $9,000 expenses for Mr. Bob Alt's Harley motor. It doesn't show the $3,000 that he spent on steroids in 2024 alone. It doesn't show all of his expenses. So the chart that they included is incomplete, incorrect, and very, very does not show what's actually happening with these partners. And I also want to note for the court that Mr. Krupp continually states that my client took all of the joint monies and absconded with them, and that's why the mortgage wasn't paid. First of all, the mortgage was in forbearance for many months. There was no mortgage due at the time of this divorce filing. Secondly, Mr. Alt had paid for his truck payment. With the joint account, my client paid her car payment. She paid the party's health insurance bill, the consumer's bill for the home, and there was $400 left in their joint account at the time she closed it out. And the reason she closed it out was Mr. Alt had essentially made the threat he was going to spend it down until there was not a dime left. So she paid the party's bills to get them current prior to closing out the whopping $400 that was left in that account. So again, we have provided documentation showing that Mr. Alt failed to do what he was required to do under the court order, that this house is in dire need of being sold before it does go into foreclosure. It does appear that as of 2 days ago, Mr. Alt did prevent the foreclosure process. But again, we don't want to wait around and see if he makes the August payment. We request that this house be sold and any proceeds be escrowed until this court can decide how those should be apportioned between the parties. Thank you.
Mr. Krupp.
Thank you, Your Honor. There's a case called Yo versus Yo, YEO versus YEO. And it says unless the asset is truly going to be lost, like the sale is next week, the sale, foreclosure sale, the court can't just order stuff sold based on emotion. By her own admission, she's saying it's not in foreclosure right now. My client made the payment. And quite frankly, yes, we had a forensic accountant go through these records. There's about $45,000 that is unaccounted for. We don't have records for PayPal and Venmo. Weirdly enough, if you see the income trends, all of a sudden 24, 25 is zero for Miss Alt. We don't know where, but yet we have records from her broker showing that she was paid, and there's no explanation of where that money went. So yeah, we're scratching our head going, where'd all that money go? Did it go into the PayPal? Did it go into the Venmo? I mean, we're spending hours and hours trying to forensically figure out where'd all this money go, because there's thousands and thousands of dollars missing, which she doesn't want to talk about. My client actually just spoke with one of his pensions that he had prior to the marriage, talked to them. They indicate that somebody cashed out his premarital pension. That's a whole nother issue in and of itself that potentially is a criminal issue. And that's about $45,000. So there's a lot of accounting that needs to be done that we're doing right now. You don't pay an accountant to do a forensic for the heck of it. There's seriously some financial problems. We got copies of all the checks. We're going through figuring out where did all this money go. At the end of the day, what's before the court is, and obviously the rest of the story is for trial, is this property subject to being lost as of today? According to Yo versus Yo, the answer is no, it's not subject to being lost today. Therefore, the court shouldn't sell it. Reality is my client walked into a temporary order thinking the house payment was current. It was 10 months behind. The question is, where did 10 months of house payments go? My client's depositing all of his funds into the joint account. She's depositing nothing, and the house payment's not getting made. He walked into a mess. Here, I'll give you the house back. It's 10 months behind. You figure it out, and dumped it in his lap. Yeah,
Watch closely. The evidence reveal will leave jaws on floor. One single detail flips the narrative in the blink of an eye.
Trying to sort it out. It's a project, but I don't think under Yo versus Yo, you can order the house sold.
And at this point, what the court will do is adjourn this motion, because I do not believe at this point that the house is in danger. So that certainly can be renoticed if that becomes an issue without paying a new motion fee. All right, then we have the motion to compel.
Yes, Your Honor, we did file our motion to compel. Again, we sent out discovery requests to Mr. Krupp and his client on June 2nd. We included the proof of service of that. We notified Mr. Krupp that we did not receive anything. It was due June 30th. We followed up on July 15th requesting where those items were. We had a mediation scheduled and obviously needed some information from his client prior to going to mediation. So we requested a response and requested the documents prior to mediation. The only response that Mr. Krupp made was to email our mediator, Mary Benedict, and say, hey, we acknowledge we owe discovery. Hey, we need to push out mediation. There was no further response. We followed up again on the 17th, noting again the house issues as well as several outstanding discovery issues, again requested when it was we could expect a response to the discovery, and there was no response, so we filed this motion. So in the interim, again, as of yesterday, I received a response to our request for discovery, so I do have a response. It is largely incomplete. Again, we requested production of documents, including PayPal, Zelle, Venmo, eBay account summary histories from his client. Mr. Krupp's general response is, well, the joint checking account's closed, so my client can't produce any of that income. No, you go to Venmo, you go to eBay, you go to these accounts and you print out your order and purchase history. It has nothing to do with whether a joint checking account has been closed or not closed. So we do have a halfway response. We did finally get that yesterday, which was more than a month overdue and with no notice. And the only thing that precipitated even that response was our filing this motion. So we are asking that the court enforce Mr. Krupp and his client actually respond with documentation which is readily available. It has nothing to do with whether a checking account is open or closed. And so we are asking for them to actually respond to our discovery request. We're also asking for the fees and costs incurred in having to file this motion to compel. And again, if the court awards that, we would submit our attorney affidavit regarding those costs and the fees.
Your Honor, we're missing her Venmo records, her PayPal records, which is, and that's what we're trying to figure out. Where did the money go? Where's the money trail? She's asking for, quite frankly, a lot of her discovery is things like provide an itemized list of every part that you put on your motorcycle, which my client doesn't have. There's significant amounts of stuff that, and really it has no relevance. A big fishing expedition. We got a 36-month marriage that we're doing discovery like it's a 30-year marriage with $1 million. I think when this all boils out, there's probably not a whole lot here, sadly. We did get the refinancing records to figure out what got paid. Her truck got paid off. We're trying to do the money trail to figure out where all this money went, which is significant, instead of just doing a fishing expedition on how much do you spend on fishing gear during your marriage. There's a bunch of discovery, which is quite frankly very irrelevant. My client indicated—
Hold on. This cross-examination is heating up in seconds. The defense pushes back hard, and the witness feels the heat.
That he can't get the eBay records because once you shut the account off, or the underlying account off, that he can't get the records. He's not super tech savvy, quite frankly. That's why he's doing Zoom with me. So finding those records is not super easy, but it is what it is. I think both of the parties need to provide copies of PayPal and Venmo accounts for the last 36 months, which I haven't gotten those from her either. So I guess I can file a motion to compel, and then all of a sudden she's going to generate those. There's clearly money missing, and we need to find where this money went. And yes, we're paying for a forensic to be done because there's so much money willy-nilly gone that we're trying to sort out. Literally, we've requested copies of all the checks. We're going through every check, trying to figure out where did all this money go? And where did, in 2024, she was working, but yeah, nothing went into the joint account. Where did that money go? So yes, we're doing forensics. We're looking at trying to get all the documentation. She needs documentation. I need documentation too. Interestingly enough, we're both arguing about Zelle or I'm sorry, not Zelle, Venmo and PayPal. Neither one of them produce those documents. I think both of them should be required to produce both of them for the length of the marriage. I have no problems with that. Again, it's stuff that needs to be generated. She hasn't generated, we haven't generated, and we actually requested that the mediation be reserved or adjourned because we haven't had a chance to digest all this information. The refinancing paperwork is, man, go get it. It's probably 2 phone books back when there was phone books of material that we're going through. We finally figured out what got paid through this refinancing, which one was her vehicle, a couple of her credit cards off of his house equity before the marriage. So yeah, there's a lot to go through. I have no qualms with producing those documents. Some of the stuff we just can't produce because they just don't exist. Producing a list of motorcycle parts, he doesn't have those. He randomly bought motorcycle parts here and there. There's stuff that just can't get produced. But I think both parties need to produce the discovery so we can actually move the case forward. There's a lot here though. There's a lot to digest.
All right, well, I am going to grant the motion to compel based on the objections that Mr. Krupp has raised could definitely have been addressed in the form of a motion to quash or protective order or all the other options that are available. But I will reserve on attorney's fees, provided there are no other discovery issues. But I do also believe that both parties should, and I will order that both parties provide their eBay, Zelle, Venmo. Was there another one?
Venmo,
Your Honor,
PayPal.
I would note that Mr. Krupp does
PayPal.
have our Venmo. Everything he asked us for was sent to him. He does have our Venmo. Those were provided to him with our discovery back in June. He has it.
Okay,
Has
okay.
our
Well,
Amazon.
all right, if just to the extent that one party or the other does not have it, those are to be produced within 14 days.
Okay, there's eBay, Venmo, and PayPal. PayPal is the other big one that.
PayPal was also attached to our discovery response sent to Mr. Krupp.
Okay,
Okay, thank you.
all right. And do we have this set for a settlement conference yet or the trial yet?
I know we don't have a trial date.
Okay.
I don't believe so. Let me double check. I can look right now.
When was this filed?
February.
Filed the very end of February, so almost the beginning.
Okay. All right.
This is it, the verdict moment we've all been waiting for. The tension breaks as the courtroom reacts to the final word.